a student at the Indigenous Community Legal Clinic in downtown Vancouver. This video has been recorded on the unceded ancestral territory of the Musqueam, Tsleil-Waututh, and Stolo nations. This video is part of the Live Law series on tenancy and will cover what it means to be discriminated against in housing and what to do if you suspect you've been discriminated against. We're also going to talk about the British Columbia Human Rights Tribunal. For more information on the BC Human Rights Tribunal, please see our video series dedicated to human rights in British Columbia titled HRT in British Columbia, the What and How. So first off, let's talk about what housing discrimination really is. Discrimination is when you or someone else receives different treatment than another person because of what are called protected characteristics. Protected characteristics include race, color, ancestry, place of origin, religion, marital status, family status, physical or mental disability, sex, sexual orientation, gender identity or expression, age, and lawful source of income. Indigenous peoples are protected under the categories of race, color, and ancestry. Indigeneity should be a protected characteristic in and of itself, however, it is not recognized as a separate category by the BC Human Rights Code at this point. The Human Rights Code has rules against discrimination in tenancy. This tells us that a person, usually a landlord, must not deny someone or a group of similar people the right to tenancy when a space is available for rent. They also cannot discriminate against someone when it comes to a term or condition of your tenancy. The code also requires landlords to accommodate your personal characteristics. This is called the duty to accommodate, and I will discuss it in more detail later in this video. There are 5 main exceptions to what the code covers. First, the protected characteristics in tenancy do not include political beliefs and criminal conviction. This means a landlord can choose not to rent to you if they find out about your criminal record. The code does not prohibit discrimination when you share a bedroom, kitchen, or bathroom with the person doing the discrimination. Further, the code doesn't prohibit discrimination on the basis of age or family status when every unit in a particular building is reserved for someone who's over the age of 55. Most seniors residents would fall in this category. Fourth, if a landlord is renting a building that is designed for those who have disabilities, the code does not prevent them from discriminating on the basis of mental or physical disability to prioritize those who have disabilities to live in that space. Lastly, the BC Human Rights Code provides an exemption for some nonprofit groups to make discriminatory distinctions in providing service. This exemption usually applies when the nonprofit group is a charitable or social organization whose primary purpose is the promotion of the interests and welfare of an identifiable group. For example, if a society existed solely to prove the well-being of Indigenous peoples, they would be allowed to prefer Indigenous applicants over others in providing housing. I think this is a good time to provide some examples. Here are some examples of housing discrimination. When a landlord refuses to rent a space to you and tells you that it's because you're Indigenous. Another example might be that a landlord evicts you because they find out that you're on employment insurance or that you have lost your job. There can be other types of discrimination too. For example, if another tenant in the building is harassing you because they found out that you're gay, if you have alerted the landlord or building manager and they don't take any action, that could be considered discrimination. Further, if you are someone who uses a wheelchair for mobility and you tell your building manager this fact, if they refuse to install a ramp at the front of the building and you can't access your suite, that would likely be considered discrimination. I think we have a good idea of what housing discrimination is and what it might look like. Now let's turn to what to do if you think that you've experienced discrimination in housing. So since some forms of discrimination are prohibited by the BC Human Rights Code, we have what's called the BC Human Rights Tribunal. This tribunal, often called the BC HRT, is like a court, but it only deals with issues of discrimination. So to get to the HRT, you must file a complaint against a person that you think discriminated against you. Sometimes the complaint is actually against a corporation instead of a single person. If you think a corporation might be involved, you should always name it on the application using its proper legal name. This person or corporation is then called the respondent because they are given the opportunity to respond to your complaint and they have the opportunity to provide defenses for their actions. In housing, the respondent is usually either the landlord or a person who has some authority over the space. An example of this would be the building manager. So what do you need for an HRT complaint? A successful HRT complaint will set out the facts that prove the respondent discriminated against you. This means you need to prove 3 things in your application. First, you need to show that you have a personal characteristic that's protected by the BC Human Rights Code. We talked about these characteristics earlier, but some examples include race, color, or gender identity. If you are Indigenous and you experience discrimination because of your indigeneity, you can make a claim under race, color, or ancestry. So second, you need to demonstrate that your landlord's conduct has had a negative effect on you in relation to your tenancy. There's two clear examples of negative effects in housing. One is that you've been evicted from your suite, or two, the landlord refused to rent you a space that was otherwise advertised for rent. But don't forget that the negative effect can be something a little bit more indirect, like a landlord applies different terms to your lease than they do to your neighbors. Or it could be that the quiet enjoyment of your space has been affected by someone's harassment. You might also be surprised to know that sometimes receiving the same treatment as others can be considered discrimination. Think back to our example of the wheelchair and needing a ramp to access your space. If you have a protected characteristic that requires accommodation, and if that landlord knows of that requirement, then continuing to treat you the same as others, as in forcing you to take the stairs, could result in a negative effect on you. You wouldn't be able to access your space. Third and last, you need to show that your personal characteristic is a factor in the negative effect. It's important to note here that the personal characteristic doesn't have to be the only factor that led to the negative effect. You just need to show a relationship between the two. Actually, your personal characteristic doesn't even have to be the main factor. It only needs to be about 1% of the reason. You also don't need to show that the respondent intended to cause a negative effect on you. So you might be wondering how you would know if your personal characteristic was a factor in the treatment. The most obvious, the respondent might identify the personal characteristic in their reasons for the negative treatment. They might say something along the lines of, "I will not rent this apartment to you because you are Indigenous." However, not all signs of discrimination are that direct. The actions might just negatively affect the complainant because of their personal characteristic. Lastly, the circumstances might show that the personal characteristic was a factor in the negative treatment. For example, the landlord might refuse to rent a suite to a couple with a child, but then rent it to a couple without a child the following week. This might be considered discrimination on the basis of family status. Now, unfortunately, even if you prove all these factors, your landlord still has the opportunity to provide a justification or defense. To use this defense, your landlord would have to prove that, first, that there is a legitimate tenancy-related purpose for their conduct. Second, that the standard of conduct would need to be adopted in good faith, meaning it would have been necessary to accomplish whatever purpose they were trying to do. Lastly, the landlord's standard of conduct must be reasonably necessary, meaning the landlord could not accommodate your personal characteristic without undue hardship. In this case, the HRT may examine what the landlord did, if anything, to accommodate you. As this video has explained, there are a lot of factors to consider in determining whether you've been discriminated against in housing, and what you need to do to prove a human rights complaint. For more information on the HRT process, and for specific instructions on how to fill out the HRT complaint form, please see the other Live Law Project video series on BC human rights. If you are Indigenous and in need of assistance with the merits of your complaint, filing a complaint, or if you require HRT representation, please contact the Indigenous Community Legal Clinic. They can be reached at 604-822-1311. If you've already filed an HRT complaint related to housing discrimination, and it looks like it has all the necessary requirements, you can't find assistance anywhere else, you might be eligible for help from the Human Rights Clinic at the Community Legal Assistance Society. You can find more information on their website or by calling 604-622-1100. Thanks for watching.
All Live Law Project content is provided by law students for informational purposes only. It is not and should not be considered legal advice. We're not suggesting that you make legal decisions based on any content included as part of this project without seeking legal or other professional advice. We cannot guarantee the accuracy of our content. The information in this project may not apply to you if you don't live in British Columbia or if the law has changed.